So I'm going to be talking about Article 160 and 170 of the CPL. 170 of the CPL is proceedings on information, simplified traffic infractions, prosecutors' information, and misdemeanor complaints from arraignments to the plea. I'm just going to be talking about a few things that I think are what mostly goes on in the courthouse. So a motion to dismiss as per CPL 170-30 is a motion made by the defendant, and the court may dismiss it if any of these options, one of these options. So it could be or A, the accusatory is defective, or B, it's immunity from prosecution, or C, there's a previous conviction, like double jeopardy. D, the prosecution is untimely, which is 3010 of the CPL. E, they're denied the right to speedy trial, which is in 3030. F, jurisdictional or legal impediment to the conviction. Or G, it's required in the furtherance of justice. Now, if anybody puts in for a motion to dismiss for any of those reasons, and the court grants the motion to dismiss, it gets sealed 160-50. 160-50 is about sealing of the records in favor of the accused, which means in favor of the defendant. So 160-50, it's going to be dismissed. Need to immediately notify, the court shall immediately notify with the sealing order anyone who needs to get notified about the sealing. And this is something that a clerk does. They do the sealing orders and send it to DCJS. So the court record, DCJS's records, the DA, and the police records are all sealed, except for an ACD and a marijuana. Now, marijuana, if something gets sealed for a marijuana case, which I'll talk about after, they're only allowed one. So the DA has to see if they're eligible for a marijuana ACOD. So that's why that's in there. Okay. So what this is now, 170-55, is an adjournment in contemplation of dismissal. This is not, it's without a date. Without a date. And that confuses me, but it's without a date. And it's made on a motion by the court, the people, or the defendant, and you need consent from the people and the defendant. And adjournment in contemplation of dismissal is 6 months. So if this is granted for, what is this usually granted for? I don't know. But let's say this is granted. It's usually for 6 months. And then if the person doesn't get arrested for anything, or it doesn't violate an order of protection within that time, it gets dismissed automatically. The person does not have to come in. So I guess that's without the date. The person does not have to appear. And if it's a family offense, it's 1 year. So family offenses are all of those offenses that are actually concurrent with family court. Any of those offenses in the DV part, the domestic violence part, the family offense is 1 year, and they can also have an order of protection at that time for the 1 year. But anyway, it just gets dismissed after the 1 year. Now, a 170-56 motion is made by the defendant, and it's for 1 year, and it's for marijuana. And neither one of these are a conviction of admission or guilt. Neither one of these is a conviction or an admission of guilt. So now if these get sealed, it's again a 160-50 sealing. Okay. It's in favor of the accused. Okay, and now generally with a 160-50 seal, it's the records shall be sealed by the clerk, who must notify these people, DCGS and heads of appropriate police departments, that the record has been sealed. The fingerprints, the photographs taken, and reports made are either returned or destroyed. Police agencies and DCGS must notify anyone to which they sent reports to return or destroy them. And generally, all official records shall be sealed. Okay. sealed records shall be made available to the person accused or the agent, and 1, a prosecutor in cases where the defendant has moved for an ACD in marijuana. This is what I was talking about, why the marijuana one is an exception, because the prosecutor can see these if somebody's moving for marijuana, just to see if the person's had one done before, because if they usually just give them one, and then after that it's like a fine or something after. So that's why that's the exception there. 2, law enforcement agency, upon an ex parte motion in a superior court, if justice requires. And I have that it could also be in a district, a New York City criminal court, and the city court. Okay. 3, any state or local agency responsible for issuance of gun licensing, which thank God for that. 4, New York City Division of Parole, when the accused is on parole as a result of a conditional release or a parole release granted by New York City Board of Parole, and arrest which is subject of inquiry is one which occurred while accused was under such supervision. 5, any prospective employer of a police or peace officer application by a person. 8, probation department responsible for supervision of the accused when the arrest which is the subject of inquiry is one which occurred while the accused was under such supervision. Okay. A report of the termination of action in favor of the accused shall be sufficient notice of sealing to the Commissioner of DCJS. 3, a criminal action or proceeding against a person shall be considered terminated in favor of such a person when an order is entered dismissing the entire accusatory instrument and not appealed, a verdict or a complete acquittal was made and not appealed, a trial order of dismissal of the entire accusatory instrument was made and not appealed, the order setting aside a verdict was entered, no new trial was ordered, and the order was not appealed, the order vacating the judgment was entered and not appealed, the order of discharge was entered and not appealed, or all charges are dismissed by the grand jury. The DA elects not to prosecute prior to filing of an accusatory instrument. The arresting police agency elects not to proceed. Conviction was solely for marijuana, controlled substance violation, and 3 years have elapsed since the offense. Okay, so the conviction was solely for marijuana. So somebody gets convicted for marijuana, they pay a fine of $100 or whatever it is, and 3 years pass. The record is supposed to be sealed. And 11, an order dismissing an action as per a German contemplation of dismissal was entered. Okay. Now, 160.55 is different. 160.55 is different. 160.55 seal is a conviction of a non-criminal offense. This is somebody who gets arrested for an A misdemeanor or a B misdemeanor where they have to be fingerprinted, and then they take a plea and are found convicted of a lesser charge of a violation or a traffic infraction, which is not a criminal conviction. They would not need to have their fingerprints if they had previously, the first time, been arrested on those charges. So this is why we seal these fingerprints. And in this case, the court record is not sealed. Again, the court record is not sealed. Only seals the law enforcement records, DCJS, police records, and the DA records are all sealed. The court record is not sealed. People don't seem to understand this, but it's not sealed. Okay. And it does not apply to loitering or certain VTL offenses, which usually is driving while ability impaired, because the person can be, the charges can be greater with the DWI. So that's why that's not. And loitering for prostitution, I guess, to see if people are previously doing it. So that's why they don't do that. Now, there are times where people waive sealing, and, well, I don't know if we need to know that for our tests, but there are times where the DA will ask them to waive sealing, even on like on a case where it's like, you know, disorderly where it's some kind of like family offense, and then they get harassed, disorderly conduct, and they'll ask them to waive sealing because they've had it before, so they want them to waive it. So that, but I don't know if we need to know that for a test. Okay, so except for loitering and certain VTL violations, I already told them that. The clerk of the court shall immediately notify police agencies and DCGS that the action was terminated by conviction for a non-criminal offense. The fingerprints, photographs taken, and reports made are either returned to the accused or destroyed. Police agencies and DCGS must notify anyone to which they sent reports to return or destroy them. Generally, all official records shall be sealed. Access to sealed records are the same list of people from the 16050 seal, and may also be made available to police agency, probation, Department of Corrections, like all those people that we said before. Okay, in 5.10.15 of the CPL, I think this is very important because it's new and changed, and it's about raise the age. Okay, it's about committing of a principal under 17 or 18. So now we just need to worry about 17 because the under 18 thing is not happening until 2019. So for the purpose of our test, it's going to be under 17. Okay, so it says commitment of the principal under 17. When a principal who is under the age of 16 is committed to the custody of the sheriff, the court must direct that the principal be taken to and lodged in a place certified by the Office of Children and Family Services as a juvenile detention facility for the reception of children. That is the juvenile offenders, remember that. Now this is the adolescent offender. When a principal, and this is new, when a principal who is 16 is committed to the custody of the sheriff, the court must direct that the principal be taken to and lodged in a place certified by the Office of Children and Family Services in conjunction with the State Commission of Corrections as a specialized secured juvenile detention facility for older youth. Where such a direction is made, the sheriff shall deliver the principal in accordance therewith, and such person shall, although lodged and cared for in a juvenile detention facility, continue to be deemed in the custody of the sheriff. No principal under the age of the specified to whom the provisions of this section may apply shall be detained in any prison, jail, lockup, or other place used for adults convicted of a crime or under arrest and charged with the commission of a crime without the approval of the Office of Children and Family Services, which shall consult with the Commission of Corrections if the principal is 16 years of age or older in the case of each principal and the statement of its reason therefore. The sheriff shall not be liable for any acts done to or by such principal resulting from negligence in the detention of and care of such principal when the principal is not in the actual custody of the sheriff. 2. Except upon consent of the defendant or for good cause shown in any case in which a new securing order is issued for a principal previously committed to the custody of the sheriff pursuant to this section, such order shall further direct that the sheriff to deliver the principal from a juvenile detention facility to the person or place specified in the order. Okay, now 430 is about determining the amount of fine based on the defendant's gain from the offense. Because if you remember, a felony is $5,000 or double the defendant's gain, right? So this is how they're going to determine the amount of the fine based on the defendant's gain. If that's how that's what they're using. In certain cases where the court will impose a fine based on the defendant's gain from the offense, 1, the court may order a hearing. 2, the court must file the order with the clerk, who must send a notice to the DA, the defendant, and his attorney. 3, the date of the hearing must be not less than 10 days of the filing of the order, and the people must prove the defendant's gain by a preponderance of the evidence. So defendant's gain, preponderance of the evidence. Violations of probation, preponderance of the evidence. Any types of hearings or, well, no, because the VOP is a hearing. But the hearing for this predicate offense, like any felony offender shit, all this shit that I said before, is proof beyond a reasonable doubt. Convicting somebody of something, proof beyond a reasonable doubt. Okay. Anyway. Okay. Now, 440 is determining prior convictions for purpose of sentencing. Okay, where a defendant is convicted of an unclassified misdemeanor or a traffic infraction, and sentence depends on whether the defendant has previous conviction for an offense, the court or the DA may file a statement of previous conviction. The copy of the statement must be received by the defendant at least 2 days before the hearing. If not, the defendant may request an adjournment, and the court must grant a 2-day adjournment of the hearing. The court must conduct the hearing without a jury, and the burden of proof is upon the people. And proof, again, is beyond a reasonable doubt. Okay. 410 is sentence of probation, conditional discharge, and parole. Some important things to know here is that where the sentence is probation or conditional discharge, the court must specify the conditions to be complied with. No, duh. I mean, come on. When the sentence is probation, the court must also give a written copy of the conditions to the defendant at the time of sentencing. This is not required for a conditional discharge, even though we still do it, obviously, but probation, they must be given the copy. The copy of the conditions also become a part of the defendant's record of the case. So that means, like, the conditions go in the file. A commission of an additional offense other than a traffic infraction constitutes a ground for revocation of a sentence of probation or conditional discharge, whether or not the original sentence so specified. When court pronounces sentence of probation or conditional discharge for certain specified crimes in the executive law, it must specify, in addition to the conditions of the sentence, the requirement to report to the Crime Victims Board Fund of the convicted person, and the procedures of such reporting and the penalty for failure to comply. The defendant must be present. Okay, modifying or enlarging of conditions of probation or conditional discharge. The court may modify or enlarge conditions of probation or a conditional discharge. The defendant must be present unless the court is relaxing or eliminating one of the conditions, which I think I've seen that like once. But so if they're modifying or enlarging, somebody can be on probation but they keep, I don't know, like running away. So probation wants to put a bracelet, like an ankle bracelet on them so they know where they are, like a GPS, so they know where they are at all times. That's an enlargement of the conditions of probation. If somebody is on, has a conditional discharge and, you know, the court says, I want them to also now, they're not complying with, you know, whatever, community service. I want them to also take this class. That's an enlargement. Whatever it is that they want to add, adding anything is an enlargement or a modification. And the court must notify the defendant in writing within 20 days. If the court's saying that they want to take off the ankle bracelet of the person because they've been doing really well, that's a relaxation. They don't have to be there, but obviously they need to go to probation to get it taken off, but whatever. So they have to notify the defendant in writing within 20 days to modify. A declaration of delinquency. The court may make a declaration of delinquency. This is when they're telling the person that they violated probation or conditional discharge. They must then cause the defendant to appear for a final determination of the alleged delinquency. If the request is from probation officer, the court must make a decision within 72 hours. So this is when, like, if you ever worked in a criminal court, you'll see that they have a declaration of delinquency, usually from the probation officer. They give it to the judge. The judge has to sign off on it to say, like, whether or not they're going to find the person delinquent based on whatever those allegations that the probation is saying, that they haven't reported, that they've been testing positive for drugs or whatever. And this is when, now after this, after the judge makes their decision within 72 hours of this, then a notice to the defendant or a warrant has to be issued to get the person there. So the court may order at any time that the person under sentence appear before it. If the court has reasonable cause to believe that a condition has been violated, the court may at any time order the defendant to appear within 10 days, 10 business days, or order a bench warrant, or deny the bench warrant within 72 hours of the request by probation. Okay. Also important to know in this section is a person on probation is in the legal custody of the court that imposed the sentence. They are under supervision of probation, but they are not in custody of probation. They're in custody of the court, which it means that they're being supervised by probation. It's like, okay, this is a stupid analogy to remember this, but it's like probation is the babysitter and the court is the parents. So the court has custody and probation's like the babysitter. I don't know if that would help anyone, but that's how I look at it. I don't know. Okay, anyway. A search order issued by the court authorizes the probation officer to search the person. For reasonable cause, probation officer may search the person without a warrant. An appearance An appearance of the defendant under probation before the court. When a person is brought to court pursuant to CPL 41040, the court may 1. Commit him to the custody of the sheriff, remand. 2. Fix bail. 3. Release him on his own recognizance. Or 4. Order him released if the court does not have reasonable cause to believe that the person violated a condition of the sentence. A hearing. Now, if the person denies the allegations, they are entitled to a hearing. The court may not revoke a sentence of probation or conditional discharge unless it finds the defendant has violated a condition and has given the defendant an opportunity to be heard. The defendant must appear within 10 days of the notice. Court's finding must be on a preponderance of the evidence. And at the conclusion of the hearing, the court may revoke, continue, or modify the sentence of probation or conditional discharge. Usually, if it's revoked, the person goes to jail. Or they can continue it or they can modify it. If they continue it, usually they don't get credit for the time that they had that was bad. So, whatever. Anyway, we don't need to really know that. Okay. The court may at any time terminate a period of conditional discharge or probation other than lifetime probation, but the court may terminate a period of lifetime probation when a person has been on unrevoked probation for at least 5 consecutive years. And the court may impose a sentence of parole on an eligible defendant who is an indeterminate sentence of imprisonment. Okay. Okay, so the 5, 10, 15 thing, what's important to note here is this line right here, is that a person under the age of 16, when they're being committed to the custody of the sheriff, they're taken and lodged in a place certified by the Office of Children and Family Services as a juvenile detention facility for the reception of children. But when the principal, whatever, is 16, and that's an adolescent offender, is committed to the custody of the sheriff, the court must direct that they be taken and lodged to a place also certified by the Office of Children and Family Services. But here, it's in conjunction with the State Commission of Corrections as a specialized, secure juvenile detention facility for older youth. It is not the same thing as juvenile detention facility for children under 16. Just be aware of that, and that they are continued to be deemed in the custody of the sheriff, even though they're not with the sheriff, and they shall not be detained in any prison, jail, lockup, or other place used for adults convicted. But if they do need to go back and forth to court, the sheriff has to take them there. And the sheriff shall not be liable for anything that goes on while they're not in there. Okay? So again, 16 years old, committed to the custody of the sheriff. Court must direct, taken, and lodged to a place certified by Office of Children and Family Services, conjunction with Commission of Correction, specialized secure juvenile detention facility for older youth. There's the key thing there. Anyway, and they're also still committed to be deemed in the custody of the sheriff. So very different, and it's a change. So just want to, I'm hoping that we get that. Okay. The only thing that I want to put in here for the fines is that a superior court may remit a fine, restitution, or reparation for any offense on 5 days' notice to the DA in the county where imposed, and to other persons required to be given notice. And a corporation must pay its fine at the time of sentence. Whatever. What else am I doing here? Okay. For 30 is about imprisonment. Okay, an indeterminate or determinate sentence. The person's going to the Commissioner of Corrections and Community Supervision. That's upstate. Indeterminate or determinate. Commissioner of Corrections and Community Service. Definite or intermittent is the local jail. New York City, counties, the Department of Corrections, in any other case to the county jail, workhouse, penitentiary, blah, blah, blah. It is the most important thing is the sentence of imprisonment is not to be changed after commencement. After the person's in, it cannot be changed, suspended, or interrupted. That's it. I'm there for that. 440. Mary has a whole video on 440. Let's see what else. Okay, 500 bail. Bail. I hate this one. 500, we have bail. Now, there's a lot of definitions here, and I can't seem to remember them, so I'm putting them all on the video. A principal is a defendant in a criminal action or person adjudged to be a material witness. Release on own recognizance means to allow a principal to be at liberty during pendency of an action. 3. Fixed bail. A court designates a sum of money, the posting of which allows the principal to be at liberty during the pendency of the criminal action. Commit to the custody of sheriff is when the court orders the principal confined in the custody of the sheriff during the pendency of the criminal action. A securing order does these 3 things. How I forgot this, I have no idea, but because I see this every day. 1, the securing order can do 3 things. Commit somebody to the custody of the sheriff, fix bail, or release him on own recognizance. Okay. Order of recognizance or bail means a securing order which releases the principal on his own recognizance or fixes bail. Duh. Okay, I'm not going to go into all of those. Okay. Post bail means to deposit bail in amount and form fixed by the court, with the court or authorized agency. Bail means cash or bail bonds. Cash bail is a deposit of money on the condition that it will be forfeited if the principal does not comply with the court's direction regarding attendance or making himself amenable to processes of the court. Bail is there so the person will come to court. An obligor is a principal or other person who executes a bail bond and thereby assumes the liability. A surety is an obligor who is not a principal. This is a third party who promises to pay. Like somebody gets arrested and the person's mom comes in and wants to pay bail. They're the surety. A bail bond is a written undertaking that principal will appear when his attendance is required and that in the default thereof, the obligor will pay a specified amount. An appearance bond is a bail bond in which the only obligor is the principal. A surety bond is a bail bond where obligors consist of one or more sureties or one or more sureties and the principal. So a surety bond, an obligor. A surety is where the obligor consists of one or more sureties, or one or more sureties and the principal. Okay, so they're going to, an obligor again is a principal or the person who executes a bail bond, and it's going to consist of one or more sureties. A surety again is an obligor who's not the principal. So it could be one or more sureties or one or more sureties and the principal. Okay. An insurance company bail bond is a bail bond in which the obligor is an insurance company. A secured bail bond is a bail bond secured by 1. Personal property greater than or equal to the undertaking. This is like a diamond ring or something like that. 2. Real property at least 2 times the value of the undertaking. 2 times the value. And that's secured bail bond. So secured bail bond is by is something physical. Okay. Partially secured bail bond is secured by a deposit of money not in excess of 10% of the total amount of the undertaking. Next is an unsecured bail bond. It's a bail bond that is not secured by any deposit or lien. Okay, let me just record this. Okay. 5/20/20 posting of bail bond and form and contents of justifying affidavits. This is something that clerk does have to do, so I think it's important to know. When somebody comes in, generally somebody posts a bond, the company needs to have these certain things in the bond. So generally, a bail bond must be subscribed and sworn by each obligor and must state these 6 things. 1, the name, residential address, and occupation of each obligor. 2, the title of the criminal action or proceeding involved. 3, the offenses and status of the action or proceeding. 4, the name of the principal and nature of his involvement in the action or proceeding. 5, that the obligors jointly and severally undertake that principal will appear and be amenable to orders of the court. And 6, that if the principal does not comply, obligors will pay to the state the sum fixed by the court. 5/20/30 is an examination as to sufficiency of the bail and the bail bonds. Okay, so a court may examine under oath or otherwise obligors or other persons who may possess information regarding bail. So let's say somebody is arrested. They want to see if the money for the bail is coming from like drug money or something like that. They would have a bail source hearing if the person posts the bail. So, okay. The DA has a right to attend such an inquiry. 2, they have a right to call and examine witnesses. The court may examine under oath or otherwise obligors or other persons with material information. The court may, upon application of the DA, adjourn proceeding for a reasonable period to allow the DA to investigate it. And at the end of the proceeding, the court must issue either approving or disproving the bail. When the bail is ordered by Superior Court after a defendant has posted the bail in a local criminal court, the defendant may request that the bail posted in the local criminal court be transferred to the Superior Court, and it usually goes with the person. A bail bond is effective and binding on obligors until the imposition of sentence or other termination of the action. Okay. Let's see what else we got here. 5/30. 5/30 is what else to know at 5:30? Okay, 5/30/12, in a family offense case, the court may issue a temporary order of protection. I'm not going to go into all the things that it can have in there, but one thing that was added in that can be in an order of protection is the return of specified ID documents. Yes. Okay, just give me a second. I'll be right up there. Okay, so what can be added, what can be in an order of protection is the usual stuff: stay away from their home, school, place of business, permitting parents visitation as per Supreme or family court orders, refrain from harassing or committing criminal offense, refrain from acts or admission to the risk of the welfare of the household members, permitting the person to enter the residence for one time only with the assistance of law enforcement to get their stuff out, refrain from injuring or killing a companion animal, and also was added on was return specified ID documents like social security numbers, credit cards, birth certificates, anything like that, tax returns, stuff like that. Okay. And order protection, now let's go into the times. The emergency order powers of the criminal court when family court is not in session. Family court is not in session. You can do a TOP on ex parte basis pending a hearing in family court. This is usually on the weekends or holidays. Somebody will come in, and the emergency TOP for family court cannot be more than for 4 calendar days. Firearms. Oh, a defendant has a right to a hearing for firearms. Firearms, 14 days. Okay. A TOP, felony, 8 years. A misdemeanor, 5 years. Any other offense, so B misdemeanor, violation, 2 years. Okay? And that is good to know because sometimes the DAs don't know and they'll ask the clerk. Anyway. Okay. Oh, 53030. Superior Court judge may order recognizance or bail when an action is pending in a local criminal court. When? 1. The local criminal court lacks authority to issue such an order. 2. Has denied the application for recognizance or bail. Or 3. Has fixed bail, which is excessive. And this just happened. This just happened. Somebody did a writ of habeas corpus. The person was in custody. Literally just happened yesterday. And the Superior Court judge actually ordered the guy to be ROR'd instead of the writ. Just ROR'd him. Okay. Superior Court, when the action is pending therein, must order recognizance or bail when the offense are less than a felony. May order recognizance or bail in other cases. Cannot order recognizance or bail when the defendant has been convicted of a Class A felony, Class B felony, or Class C felony for sex where the victim was less than 18 years of age and the defendant was over 18. Okay, the court may revoke recognizance or bail. You must hold a hearing. Can remand the person for 72 hours. Oh my God, 540. Ugh. 540, forfeitures of bail and remission thereof. Okay. Ugh. A bail bond or cash bail upon being forfeited together with the certified copy of the order of the court must be filed by the DA in the office of the clerk of the county where such order was issued within 120 days of the forfeiture. If there is forfeiture of bail that was posted in a city, town, or village court less than a felony and the bail consists of a bail bond, I'm not even, okay, that's it, okay. Financial officer shall start an action for recovery of the amount of money specified. The bail consists of cash bail and is in a city court. Bail money shall be paid to the financial officer of that city. The bail consists of cash bail and is a town or village court. Generally, the bail shall be paid to the state. Okay. An application for remission of forfeiture of bail must be made within 1 year after the forfeiture of the bail is declared and must be on 5 days' notice to the DA. I'm not doing 720 and I'm not doing 722. Well, actually, maybe.